meeting.
Great, thank you. So I'm going to speak to you a little bit about trademarks, the wonderful world of trademarks, which is one of my favorite topics, obviously, being a trademark agent and a lawyer. So, what is a trademark? A trademark can be a word, a symbol, a design, or a logo, or other distinctive element that is used by a person or a business to distinguish the wares and services in which you're going to use your mark. What you may not know is that a trademark can also be a sound or a smell. And in fact, there's just one example of a trademark that we all know probably very well, some of us maybe too well. This year, the Canadian Intellectual Property Office actually started accepting sound marks. So those were available in the US before, and now they're available in Canada. So that's pretty interesting. Trademark rights may also be acquired in distinctive colors and three-dimensional shapes. So I'll show you a few examples of those. So you can think about that for a minute. This is sometimes referred to as trade dress or get-up in the industry. A trademark can also be recognized at common law. That means you don't necessarily need to have a registered trademark to have rights in a trademark that you're using generally in your business practice. What is the key element is that it must be distinctive. So it's distinguishing your products and services from those of other people's by using this mark. The key concept also is use. Distinctiveness must be established by long-standing use, which starts with your common law rights acquired in the mark, and those can basically, after a long amount of time using it in commercial practice, you can have acquired distinctiveness. Some of the examples is what I mentioned there is the Coca-Cola bottle shape. That's one example of a distinguishing guise. Another example is the Volkswagen bug shape or fiberglass pink. You also might be familiar with the little blue pill, if anyone knows what that is, Viagra. So Viagra was able to get a registration for that as well as obtain it at common law because they basically made an association of the color blue, which is applied to the surface of the pill. And so when you think of Viagra, you think of this little blue pill. Another example is the sound of this, a Harley-Davidson engine. Another example, I can't hear it, but is an MGM line roar. I won't do a roar for you. And the lightsaber sound. So, as you can see, there are some sound marks already obtained in the US, and now we can do this in Canada. I find that exciting. Where a trademark becomes widely recognized, it also commands broader protection. So these are some examples: Superman, Nike, and McCain. So they have a broader scope of protection. So that's what this means is, let's say you go out and you want to start using a check mark on running shoes. Well, Nike's going to come along and say, no, we have the swoosh. It looks very similar. Consumers are going to be confused that those marks or that those shoes you're selling are actually our products. Therefore, you're passing off your services as ours, and they're going to come after you and claim infringement passing off. I'm going to explain examples of strong marks and weak marks. We like to think of trademarks on a spectrum. So you have some that are very, very distinct and others that are weak. And the reason why they would be weak is they describe a character or quality of the goods or services with which you're using them. So strong marks are fanciful or coin words. That means something you've completely made up. It's a new word. It's not in the dictionary. No one's thought of it. So these are arbitrary marks. So Kodak and Exxon are good examples. You may also think about Xerox. Weak marks are things where they, as I was saying, they describe the goods or services or characteristics of those goods or services. So purely descriptive marks are not registrable. When you go through the examination stage, you get an objection from the examiner as something being clearly descriptive or deceptively misdescriptive. Suggestive marks can be registrable through some argument. And what they do is they just suggest in some way an attribute of the goods or services, but they're not outright describing them. So something to be aware of if you're thinking of registering a trademark or using it is that there have been marks that were registered but then lost their registration because of generic use. So escalator is a good example. So ways to avoid that would be like saying, I have a cold, pass me the Kleenex is an incorrect use. I have a cold, pass me the Kleenex tissue. That's an example of how someone might lose their trademark because of generic use. Others have had to rehabilitate their marks, so rollerblade, Jeep, aspirin, and Kleenex. They had to send out demand letters to try and get back the distinctiveness in their brands. Other examples of words or things you would come up with that would not be registerable is if it's a name or surname. Also, as I mentioned, being clearly descriptive or deceptively misdescriptive, a common generic term. If it's confusing with an existing trademark, if it's a protected geographical indication for wines or spirits, these all come out of the Trademarks Act, and pre-existing prohibited marks and official mark. So the Olympic rings is a good example of something that would be an official mark. Now, there's a difference between a trademark and a trade name. So you can use your trade name. So let's say Microsoft Corporation. They use Microsoft Corporation to describe the business, but they might use Microsoft to describe the trademark, or to use it as a trademark. So a business name registration would be the incorporation of a company. This can give rise actually to rights in the name as trade name use, but you're not going to get the same protection that you would as a trademark to prevent other traders from using a similar mark in association with similar products and services. Now, one thing, when you're thinking of a trademark, on top of all these other considerations, you really want to make sure you do searches to figure out what's out there. So adoption of a business name or a corporate name in Ontario, so doing a business name registration through Nuance, for example, if you're familiar with that, is not going to give you rights to the name as a trademark. You'd have to do separate trademark searches on the Canadian Intellectual Property Trademarks Register. So full clearance searches is something that we do when people come to us and they say, I want to register a mark, or I'm thinking of registering a mark, let's see what's out there. We look at everything from business directories, domain names that are out there, the Trademarks Register, and other common law sources, to basically give you an idea of what the territory's out like there and what kind of objections and companies that may say, no, you're going to be infringing on this, and people, when you go through the registration process, what objections will probably be raised by third parties. The problem with what happens when you don't do searches, and let's say you've got really excited about a trademark and you've developed brochures, you've got your website up and going, you've got business cards, and then you do searches and you realize someone else has the exact mark. That's going to result in lost investment right there that you put the money in. So that's why we recommend searches. So, why register? You basically want to consider registration because even though you have rights at common law, it gives you a broader scope of protection. It's usually about 12 to 18 months, but there can be objections that are raised to redefine where their services if something's vague or overly broad. A descriptiveness objection, if it's a name or surname of someone living or dead within the last 30 years, things like that. You can have 4 bases of use when you register a trademark. There's use in Canada, there's making known, foreign application of registration and use, so that's you've got registration in another country and you're going to use that as your priority filing, or you've used it in another country. Also proposed use in Canada. That's something that people may not know, that you don't necessarily have to have used your mark to get a registration for a mark you intend to use. Eventually, before you got to the registration part where it's getting finalized, you'd have to file a declaration of use and have used it. So the examination stage comes after you file, then you've got examination, and then you've got advertisement, which I'll speak about in a second. So as I was saying, the examiner can raise a certain amount of objections, and it's basically going back to how unique and how distinct is your mark. And there's a set statutory criteria that prohibits you from registering certain marks if they're clearly descriptive, confusing, or a surname, a last name, and there's a whole other list, but they're less interesting. Basically, these will be based on invalidity or inadequate description of goods and services, and we get this a lot where you might say a mark in association with restaurants. Okay, that might be too broad, or you need to describe it further, or you might say porcelain products, and they're going to go, well, what kind of porcelain products? Those are the types of things that we need to get specific on. As Armand was saying, we want to give you broader protection, but an examiner is going to want to narrow it down. So then you go into the opposition stage. This happens after you've gone through examination. Once you pass that hurdle, it will be advertised in the Trademarks Journal, which comes out weekly. This gives an opportunity for third parties to oppose your mark, and they have 2 months from the date that it's advertised. This is a tight deadline that we have in our database, a search system, so that we're constantly watching clients' books of marks to let them know, okay, this new mark has been advertised, you have an option to oppose it, and then at the same point, if you're the person filing for an application, other parties will have a chance to oppose your mark. But if no opposition is filed, then it will proceed to allowance, and then once you've provided a declaration of use, if you've based on proposed use, then you will file, pay the registration fees, and you'll have your registered trademark. So the benefits of registration is that although at common law it's automatic upon use of the mark, it's limited. You have a broader scope of protection. You have exclusivity of your mark in association with the wares and services covered in your application to prevent other competitors or anyone else out there using a mark that would be similar, confusingly similar, or the same mark with similar products and services in the same type of industry. At common law, it also limits you as to what your opportunities are to prevent other people from infringing on your mark. At statute, Kevin's going to speak more about infringement and what that means in association with each type of IP protection, but at common law, you only have passing off rights, and they're a bit more limited than going for infringement. Also, I should tell you that it's 15 years, so patent protection is different, and copyright and trademark, all IP have different grants that are given to you. So this is 15 years, but it is renewable. So it's not like in patents where it goes into the public domain after. You can renew that after 15 years. It also confers a benefit of presumptions that you are the owner of that mark and that you have the goodwill, and as long as you're properly marking it, it's giving notice to the public that you have an exclusive monopoly on this mark in association with a certain set of goods and services. And it also gives you that right of action to go after people who are infringing your mark. So it's also an excellent branding opportunity, because once you get a trademark out there and you're using it, then like Nike, Coca-Cola, McCain's, all of those have got good branding, and it's because of their trademark use and developing that goodwill in the business. It also gives you competitive advantage over other people who don't have a trademark registration, and it gives you a reputation in the industry. So trademark notices. These are what you need to basically tell the public that I'm claiming rights in this subject matter. It basically serves as your identity about your business and the products and services that you're offering in the marketplace. So if you have a registered trademark, you use the R or the circle. What people may not know is that you can actually use the TM symbol if you're just using a trademark but you don't have it registered. MC is also an acronym for, in French jurisdictions like Quebec, it's marque de commerce for unregistered marks as well. So, what to look out for? You want to preserve your mark. The way you do this is you use it. Use it or lose it, is what I like to say. You have to use it in an ordinary commercial trade. So you actually have to be selling products, operating a business, and using this mark. You also want to have consistent and continuous use. The reason for this is that people, if you're not using it for a period of 3 years, there's something that happens in the trademarks opposition jurisdiction where someone can come after and basically try and invalidate your mark for lack of use. And you want to be consistent. So if it's that you're always using this red mark with the red symbol, you have to use it that way. You also have to use it as registered because you don't want to deviate from what is actually in your registration. That happens over time if you rebrand or you update your logo for a slightly different design, it's harder for us to establish that you still have the same use from the date you actually registered it to the time that you're using it. You also want to use it in the proper possessive form. So I was giving you some examples there, and you also don't want to, you want to use it in combination with a generic name. So some of the examples are, like, incorrect would be Oreos, correct would be Oreo cookies. Oh, this is a good one. Xeroxing versus Xeroxing, which everyone uses all the time, or copying on a Xerox copier. You don't often use that form of the Xerox mark, but that's how it should be used. So another example would be inline skates versus rollerblades, tissues versus Kleenex, sport utility versus Jeep. You don't want to use it as an adjective, or so you do want to use it as an adjective, you don't want to use it as a noun or verb, and you don't want to use trademarks in plural form. You also want to be policing the marketplace. So looking out there for other people who are using your mark, you don't want to be in a situation where it's deemed consent, that you've allowed other people for 10 years to be using it, and you've operated a marketplace, and there's no confusion among consumers. So you want to be policing it and sending a demand letter if you see anyone else using your mark. So next I'm going to talk about domain names. We can have questions at the end of the section, or if you want to do it now.
Any questions at this stage? Okay.
One question here.
Yeah, go ahead.
Perhaps if they're not using a name, but they're using a name that's similar, how similar does it have to be, and can you still send that as a demand letter in that case?
Yes. So if something is confusingly similar and it's in association with the same products and services, then yes. But you have to remember that a trademark is always used in association with product and service. So let's say you have one mark, someone else can have the identical mark for an entirely different type of service or products that they're offering, and that's okay. Those same marks can exist on the trademarks register. But if it's substantially similar and it's going to cause confusion, then yes, you would go after them, and then that's when the argument comes in to try and use case law and explain why you were right and they were wrong. Yes.
You mentioned you could use the TM without registering. So if I were to register a company and I use my company name, I put TM on it, and somebody else tried to register that name, they would not be able to. I could go after them.
Unfortunately, no. So there's 2 points there. So if you're using it, you want to be distinctive using it as a trade name or a trademark. So if you're using something as a trademark, you want it to stand out and be distinctive from surrounding text, things like that. As a trade name, you could use it without the TM. If someone else registers, it is sort of a first to file system, but if you have long-standing use, so let's say you've been using your mark and you've got a very big known reputation and you've been using it for 20 years and people know you, then you can actually oppose someone else's registration. But it is a first to file, especially if it's only recently been used. I mean, we'd have to assess it, look at the situation, but you might be out of luck for someone who files. That's why you would encourage registration so that you don't start using it and then someone else has locked it up.
Okay, I have a question. Now it's like a real life situation. Like for example, we're planning to get into another market, say USA. We're already established brand here with a trademark and everything, but we're not going to be there. The competition, for example, has come to know that we'll be there soon. We cannot be there for a year or X number of months. So if we go and get ourselves registered there and have the TM and maybe start the operation in a year's time and then get ourselves registered, so would that be a real thing or a logical thing or a legal thing to do?
So a lot of it is a business decision about if you're using it in Canada and you plan to use it in the US.
Yes.
But there is what I was saying is a priority filing system. So if you are using your mark and you registered it in Canada, you can actually file in the in the U.S. Using a U.S. trademark agent based on proposed use, and you can actually get the benefit of the earlier filing date in Canada. There is a 6-month convention priority, which we'll probably go into a bit more detail later, that gives you rights over someone else who within that 6-month period registers in the U.S. Well, actually, you've registered in Canada, so you trump them in terms of registration. The main thing is in Canada, you can file based on proposed use and as well in the U.S., but you have to be sure that you're going to be using it within 3 years, because eventually when it goes to...
3 years.
Yes, is that the same in the U.S.? I believe it's the same in the U.S., but Kevin's going to answer that.
Anyway, you can hear me, and the reality is that both in Canada and in the U.S. you can get extensions of time
Yeah.
if you need to, and so it's better to file on the basis of proposed use initially, and then just extend out and extend
To lock
out.
it up.
But usually there's a limitation to the number of extensions that you can obtain. So unless you have a really good reason for extending it, after a certain point, they're gonna saw it off there.
But 3 years is the first.
Yes, definitely. Or I mean, most likely, if in a year you think you're going to be using it, you're using it in Canada, then yes, it's a good idea.
Yeah, and usually it would be 3 years from, in the US at least, you would have 3 years from when they said it was going to be allowable. So that's not really from the point of filing. You would actually have maybe as much as 5 years from the point of filing to establish.
Yeah, because you'll file, you'll go through examination, it'll be advertised, and then you'll get an allowance.
With trademarks, there usually will be goodwill towards it. How do you value a company if it comes to trademarking?
How do you value a company when it comes to trademarking?
That's more of a, that's more of an accounting question. It has less to do with sort of what we as lawyers tend to do. It's more of
How do you
a,
quantify?
yeah, it's more of an actuarial thing. They use, accountants use different methods to assess the value of trademarks. They may use comparables. They may use a licensing rates. They use like a licensing model and say, well, okay, if you were licensed the trademark, what revenue would you generate from it? There's a whole bunch of different things.
But if there is goodwill associated with the mark, so if you were entering into agreement to transfer the business or sell that type of part of the business, then as you said, there is goodwill associated in that IP, but it just makes it very difficult to quantify that
For us, but I mean.
for us.
For
But
us.
there are people who have
You
jobs.
see it on balance sheets all the time,
who can do
right?
that.
So clearly if someone's doing.
Okay.
The 6-month grace period that you mentioned, does that span across other countries or is it just US, Canada?
Yes, other countries, anyone who's subject to, I'm trying to think any countries, it would be the EU, US, Canada, 140 about.
But EU would be one application, right? Like Europe would be one application?
So you can do a community filing, so you can file in the US, you can file in Canada and different countries, but you can also do a community filing, but you have to have use in a country within the EU, but you go through, it's kind of like the PCT filing, where there's one main office for the EU.
But you're not limited, you can, there are several jurisdictions in Europe that you can obtain the registration in that specific country, in addition to the community
Yeah,
trademark registration.
it's more expensive because you've got such a broad jurisdiction, but yes, you can have more than one country.
Why would you do it in addition? Wouldn't the community just cover all of Europe?
Yeah, but
But if you're only going to be using it, let's say in Germany, it might be cheaper to file just in one country than in the EU jurisdiction.
What role, if any, does intent play, for example, toward damages?
So, okay, so, well, I'm working on a case right now where that's an issue. So when it would have more of an impact if you had a registered trademark or a pending registration. Someone files or starts using the exact type of mark in association with same wares and services. Where it goes to damages if you can actually prove that you have damages by someone else. So you, as soon as someone else starts using their mark and you see a giant loss in profit and customers are leaving you and going to the other company, then that can go to punitive damages too. If they brought this action maliciously, knew about you, or say you had an agreement already with this person, maybe it was a related company or used to be at the company, then that can go to your damages.
But they don't actually have to know about you for them to have to stop using your.
Sorry, no. You can go after people who may not be aware of you, but you can still claim and say, no, you're not allowed to use this. I have a registration, therefore you can't use it.
Lack of awareness is not a defense to a trademark infringement suit.
Okay.
You can't say I didn't know that it existed.
Yeah, and I'm talking about trademark. I'm not talking. So even if you don't have it registered, wouldn't that still be the case?
So in a common law context, you're
Yeah,
saying
like-
in a common law context, you haven't registered your mark.
That's right.
You found out that someone is using a mark that's confusingly similar or exactly the same. They don't know about you.
It's a question, I think, as well of whether you're actually known. Like, in a common law context, you're only going to be given protection to the extent you have become known. So, for example, if I'm just using my trademark in southwestern Ontario, and somebody's using even the exact same mark in BC, if nobody knows about my brand out in BC, and I am likely on a common law basis not entitled to protection out there.
Whereas with the registration, it's federal protection, so it's all across Canada.
And it's deemed notice as well.
Yes.
So because there's a registration, it's deemed to be giving everybody notice of your trademark across the land, right? And so also, just as there can be geographical restrictions, there can be field of use restrictions as well. So for example, I might have a trademark in association with board games and actual just physical board games that I use on a common law basis. But I might not be known at all in the online gaming situation. So I likely am not going to have any protection for online games. It's possible anyway.
Right. But Kevin, if it's the same area, it's the same kind of business, they're both, this second person comes along is using something confusingly similar to yours, and nobody's registered.
Then you're probably going to get damages, even if they don't.
So you don't have to seek to prove that they know about you.
No, the question is more what Mimi said earlier, which is confusion.
Yeah.
If there's confusion, then there's the potential, and if you've suffered damages,
Yeah.
then
And
somebody.
some of the confusion, maybe I'll just give you an example so you can help you answer your question. So confusion, it actually comes from a section of the Trademarks Act, and not one factor is going to be more determinative than the other. It's basically applied contextually and looking at all of these factors. But you basically looking at the inherent distinctiveness of the mark. So something like Xerox, for instance, versus another mark that's very descriptive. They look at which, this is with a registered mark. I should have said passing off is the test when you're, in your example. It's a different test, but you do have to show that someone has, it's a tricky test. That's why we want to register, because it's harder to prove passing off, especially with unregistered trademarks. If you were using it for a long time and someone else came along, then you're in a better position. But if you both start using it at the same time, it's going to be hard to show your damages. Okay. Domain names. So domain names are different than trademarks and trade names because you can actually have a trademark or a trade name contained in the domain name itself without being an actual trademark. Domain names are a no man's land because basically someone else can come along and register a domain name that contains your trademark or trade name, it's a first come, first served basis. And there's a lot of companies or people out there that do a very good job of this, and then will try and get you to sell, or they'll want money from you to sell a domain name that you want back to them. There can be a big profit to make in this, so that's why we recommend, if you want to register a trademark and you're thinking about that, before disclosing that and getting materials out there, disseminating brochures, etc., you want to lock up those domains. So .ca, .com, .net, those types of things. You want to thwart cyber squatters and infringers by not only registering just the, say, Nike.com, but also unregistered trademarks of interest, so something similar that you're pretty sure you're going to use in the future. Names containing your trademark with additional terms, so Nike shoes, for instance. And trademark misspellings is a good idea as well. So when you're typing on the keyboard, common misspellings of a certain word, you might lock that up for the last letter being a slightly different letter and variations, so that traffic isn't directed away from your site. So there's been some new developments in the last year, and one of them you might have heard in the news is the .xxx domain registrations. This was allowed by ICANN, which is the actual domain management system, which is called the Internet Corporation for Assigned Names and Numbers. They basically approved registration of the .xxx domain names after more than a decade of people opposing this and debating this issue, whether or not this should occur. So initially it was members of the adult community who were allowed to register these .xx domains, registered trademarks and existing domain names, but at the same time members of non-adult community could block people from using this by reserving them with ICANN. So if they know that they didn't want their domain name, a similar domain name, to have .xx, people were reserving them. Since December 2011, now anyone may register a non-resolving .xx domain name on a first-come, first-served basis. This new development is relevant for brand owners, so if you have a brand or a trademark out there, because offensive websites can cause damage to your brand and your reputation and cause depreciation of goodwill. So that goodwill that you've built up using your mark and that reputation can be thwarted by these .xxx when you think it's diapers and babies and you go to a .xx and it's different. A good thing is that ICANN has provided mechanisms to prevent abusive registration. So there's a very quick, rapid takedown process for well-known registered word marks, personal or professional names of individuals, and within 48 hours these complaints can be launched, and ICANN will take down these .xx domain names pending an outcome of a decision, and there's a dispute resolution process in place. The other new development you also may have heard about is these new GTLDs. So a top-level domain is the ending of a website address. So right now there was 22. So .com, .net, .org, .ca we're very familiar with. But now there's thousands already released and published by ICANN that companies and business owners can have. That happened in June of 2011, and they published a list of, I think it was 1,930 domain names that were being released. So .cloud, .music, .lol. You can imagine that Google was a big player in trying to secure, and is a big player trying to secure a lot of these types of domain names. There is an objection period going on for people who don't want these big players to, and other companies to lock up these .cloud, .music, etc. And this has been going on for 7 months and will continue into January. So ICANN has developed what's called a prioritized system, where they put together a draw. And it's not cheap, but it can also save you costs in the long run for having to go after someone else who's using confusingly similar products and advertising with trademark use using, let's say, your brand at the end of a dot. If you're Xerox, for instance, dot Xerox. So it is expensive, but you'll, as business owners, it's something to think about in the future because it's an excellent branding opportunity. So by 2013 and early 2014, there's going to be thousands and thousands of domain names that are released that are all up for grabs. So .bank, .insurance, .law, even for local businesses, .toronto, .geographical names you can have, so you can have your business trade name, .the city. There are accepted ones that no one can have, which is like .olympic, similar to the official marks, where you can't use an official mark by a public authority, Red Cross, ICANN, etc. So this is a substantial increase. It makes it harder to police what's out there for confusion complaints and trying to preserve your trademark as being distinct.
Question on that. So if you buy, let's say, the .bank, does that mean no one else can have .bank? Is that what you're saying?
Yes.
So I could have Canada .bank,
so
but that means no one could do like Ontario .bank.
No, so what it will mean is you are going to, actually, this is your next question. What it means is you're going to own and manage that. So .com is owned by a separate registrar, and so you will own and manage it, and then people can come to you to get domains at .bank, for instance.
Got it.
So it's expensive, but then you become the owner and the operator of that .bank. So again, various themes related to your products and services, company names, trademarks, entertainment, real estate. There's going to be a long list. And then Coca-Cola can be Coca-Cola.Coca-Cola and Nike.Nike. So it's just reaffirming that brand, because if you get, like, if it's Heather Smith at .Coca-Cola, that's reinforcing brand recognition every time someone registers with that domain. So a few things that are different is that trademark owners can enter their trademark records into what's called a clearinghouse. So if you already have a trademark locked up, then ICANN is going to reject the application because you basically put them on notice that this is in your clearinghouse, I have a trademark, and therefore they can reject it. Once GTLD applications are published, then also trademark owners have an opportunity to file a formal objection to a new GTDL, which infringes their rights. So basically, the test will be if the GTLD creates a likelihood of confusion and impairs the distinctive character of the mark, then it will be rejected. A lot of this is unknown because it's very new, so it's going to be a new territory for us to figure out as the laws change with it. And one last thing, domain names, what to look out for. As I said, it's going to increase some branding opportunities, but can also result in customer confusion, online fraud, cyber squatting. It's also important enforcement considerations, because now there's not just .com.ca and all those 22, you've got so many more domains to be worried about. It's going to affect a budget, so if you have a company budget for specifically devoted to protection of your mark or enforcement, you're probably going to have to increase that. You might also have to rejig your company filters, for instance, so that you can be checking and navigating adult community sites. Whether or not you have a trademark or not, it's just something to know that this is developing, it's changing, it's something to be aware of, and it can have great opportunities, but it also can have consequences for you. And now on to copyright.
I know we're running kind of a little longer than we expected, so I'm going to try to go as quickly as possible through it. But still, something I should have said at the outset, please do, don't hesitate to jump in if you have a question as we're going along. Although I will reserve some time at the end as well for questions if we have, well, if we can. So, that said, I think we're going to try to complete another round of speakers within the time remaining to us. So I am, as I say, going to try to keep this short. So copyright, first of all, it plays well with others, and it has an interface with trademarks, which is one of the things that we already talked about. And in fact, copyright may exist in every logo and design mark that's out there, including all the ones that this presentation has been brought to you today by. Anyway, so it also plays with patents. There's a clear interface with patents as well because, for example, in the context of software, you can protect an algorithm, a way of performing a function basically as a process, or even some would go so far as to call it a business method, such as in the one-click patent case. And that's basically what I've shown there. But on the other side of things, in the copyright context, programming languages are considered to be a language. And in fact, software code is considered to be just written in a particular language, and it's not quite as compelling as a novel that you might read, maybe, sometimes, for most, but it is still protectable by way of copyright. And in fact, it is protected from the outset. So really, there is this clear interface with both trademarks and patents. So that said, what is copyright? Well, it's the exclusive right to produce, reproduce, or distribute a work. And works can be musical works, artistic works, dramatic works, or literary ones. And like I was saying, software code, for example, is considered to be a literary work. So that these categories are, in fact, potentially broader than you're thinking of at the outset. Now, the exclusive rights that are bundled up with copyright also include the exclusive rights to import, translate, sell, publish, and perform in public. And it also includes a right to authorize other people to do these things as well. So copyright, continuing on with it protects the expression of an idea, not the idea itself. So kind of like on the patent side, how you can't protect an abstract idea. Well, you can't protect an abstract idea on the copyright side either. You do have to give it a fixed form. It does have to be original, much like on the copyright side as well. So by fixed, you could fix it by recording it, by writing it out. You could fix it by putting it on a videotape or any number of different ways. But as long as it is fixed, then potentially copyright protection will apply to it. Now, it is a time-limited monopoly, much like some of the other rights that we've talked about today. Patents, it was 20 years from filing. Trademarks, 15 years renewable registrations, so 15 years and then another 15 if you renew. In the case of copyright, it's generally the life of the author plus 50 years. So it's going to live on past the life of the author and is potentially then also something that can be handed down. In some cases where a company is the first owner of copyright, then really it's just 50 years protection because the company isn't deemed to have a finite life that is going to start the clock ticking, so it just starts ticking from its creation or from its publication, as the case may be. So now there is a copyright registration system. As with trademarks, it's not necessary to register your copyright. But there are some advantages to doing so. And a few of those, it creates a certain presumptions, much like on the trademark side. And one of the presumptions is that whatever it is you're protecting by way of the copyright registration, that it's worthy of protection, that it's capable of protection. If somebody else wanted to prove that there was no copyright in such a thing, it would be up to them to prove that. You would have the presumption otherwise weighing in your favor. And similarly, it creates a presumption that those that are listed on the copyright registration are in fact the owners of it as well. So if there's some other author or somebody who claims to have authored it, they're going to have to prove that to be true. And last, it also serves as a notice to the public that's sufficient to permit recovery of damages. Because otherwise, without a copyright registration, your only remedy may in fact be to get somebody else to stop infringing your work. So with the copyright registration, then there is some further advantage. Now, a related concept is moral rights, and these are generally the rights of an author to protect the integrity of a work, that is to control it from being distorted or mutilated. It's the right of the author to be named as the author, or to go anonymous or under a pseudonym. And then it's the right of the author to control the association of the work, that is with other works or causes or entities. And that author has the ability to do these things where, in their assertion, to do otherwise would be to the prejudice of their honor and reputation. I'm not going to go too much further into this. It's, I think, a very interesting area of law. It's distinct from the U.S. context, actually, a fair bit, where moral rights aren't as recognized. And an important point on moral rights as well is that they can't be assigned. So a company can't own the moral rights in something. Only the author can own those, and the author must waive them if the company is going to freely transact in the copyrighted work. So as a company or as a startup, you might want to consider getting those waivers of moral rights at the outset, because otherwise your potential investors or people that you might be talking to will ask, oh, do you have the moral rights waivers? And you'll say, yeah, I'm going to get them. And then they'll say, oh, okay, well, just contact all the authors, and they may have all moved on, or some may no longer even be around to assign these rights. And so then you might be dealing with an estate and all kinds of messy situations. So it's always nicer if you can kind of tie it up in a nice, neat bundle for somebody to pick up and buy, hopefully, at the end of your career. Anyway, so copyright amendments, there are some, and there has been some news about these copyright amendments, and they soon will be enforced. In fact, they've been approved. I don't know if you're aware in Canada, but unlike the situation in the US, we can actually download music from the internet without fear of reprisal, as long as that's really for just a private use. What you can't do is upload music to the internet. So there's no sharing of music. Only the people who download are permitted to do what they're doing. And anybody else who wants to put it up there and share it with others is infringing copyright. But what Canada hasn't done with these copyright amendments, interestingly, I think, is they haven't amended that. So you can still continue to do that. And in fact, we've seen a little bit of a shift towards users' rights, and that's not just here in Canada, but worldwide. Now, there are a few other personal use exceptions that have been added to the Copyright Act of Canada, and one of those is a limited parody exception. So first of all, what I mean by exceptions is that to do these things, it won't be an infringement of copyright in the underlying work. So if there's, I don't know, the latest James Bond movie, for example, it wouldn't be, in Canada, an infringement of copyright to make, let's say, a substantial use of the material in that movie if you're doing so for the purpose of parody. I'm not sure that you want to do that, but that's a different thing. Another exception is the ability, they formalize this, to move content across formats. And so people have been doing this for a long time, ever since turning records into cassette tapes, or making MP3 copies of your CD collection. Now you're allowed to do it. Before then, you might have been infringing copyright the whole time. Another thing you're allowed to do that you've probably been doing for a long time is record television programs, let's say on your PVR, to watch at a later time. And so now there's an exception for personal use provided for time shifting of programs. So another important aspect, I think, though, of it is that there is this prohibition on circumventing digital locks. And so, for example, when you buy a DVD at a store, as opposed to a mall like Pacific Mall or somewhere, anyway, when you buy a DVD at a store, it oftentimes comes with locks built into it that won't allow you to make copies of it. And so now what they've done, much as in the United States, to make it wrong or an infringement of copyright or against the Copyright Act, to circumvent those digital locks. And last, I think important as well, in Canada, it's a distinction from the situation in the United States. What they have there is what they call a notice and takedown system, so that, for example, if I'm Viacom and I own the rights in a soccer match, and somebody's put a copy of my soccer match up on YouTube, then I can notify YouTube that there's an infringing copyright, something that may infringe my copyright up there. And unless YouTube wants to risk copyright infringement, that it's infringing my copyright, then they'll have to take it down. That's the system in the United States. It's notice and takedown. Whereas here in Canada, it's just a notice and notice system. So for example, let's say on the Globe and Mail website, there was some work that you believed was infringing your copyright, you let the Globe and Mail know, and all they have to do instead is just pass that notice on to whoever it was that put that up there. So for example, they would say to, I don't know, user number 745, we received a copyright notice that this work that you put up there is infringing our copyright, and we're not going to be held accountable, but at the same time, they don't have to take it down. But anyway, that's going to be the system that we'll have in place for them. So, copyright, what to look out for. So first of all, I'd say there's this interface with other protections, and it's important to make the appropriate use of copyright where you can, because it is, in many ways, a very inexpensive alternative and a one you can protection you can get relatively quickly that you should take advantage of when you can. Now, you'll want to ensure you have the proper copyright notices in place. Now, I had a fancy graphic that was going to drop down that red circle around the copyright notice that's been on every slide that we've processed so far. Somehow it's been modified. I don't know what happened. But in any case, that's the copyright notice that I thought I was going to really impress you guys. So then another thing that you should consider doing is to register your copyright. And that's especially important if you intend to rely upon it or enforce it. And then lastly, I'd say get your copyright assignments and your moral rights waivers in writing. And remember that only authors can own or waive their moral rights, not companies. So that's copyright. Feel free to jump forward with questions now. Otherwise, there will be another opportunity at the end of the design section as well. So I'm going to move on in the interest of time. So designs, what are they? Well, these are features of shape, pattern, ornamentation, or design that are applied to a useful article. And so those could be, and I've shown pictures here of an iPod and a running shoe. Now, you can see just by looking at these things that, for example, patents are going to protect the way that an iPod works, but a design is going to protect potentially the way that it looks. And similarly, I don't know, I'm guessing then that these spring-like functions on the back of this running shoe, that they don't actually have some sort of function, that they are actually just features of shape, pattern, ornamentation, or design, that they're not actually springing the person forward. But assuming they aren't, then you can protect them by way of designs. If they were, protect them by way of patents. So, I don't know if I'm clear enough on that. But the point here is that there is an interface. And just like on the copyright side, how copyrights interface with both patents and trademarks, similarly, all three of these interface with designs. And if you remember the graphic that I'd thrown up earlier as well, you then have really a truly kind of interfacing system, so that if you can take advantage of all of these together, you can potentially fill in some of the gaps that you might otherwise have in your protection. I'm going to go through some of these interfaces in a little bit more detail, but one of the ones I'm not going to spend any time on is the interface with copyright, because it's too complex. It's in this slide. You can take a look at it. If you have questions, ask me about it. But it is a little complicated. I'm going to summarize by saying that if something is capable of being protected by way of a design, and you make more than 50 of these things, then potentially it's not an infringement of copyright to make a drawing of that designed item. There are exceptions to that, so that doesn't apply to buildings and cartoon characters that you might make drawings of and whatnot. But anyway, as I say, it's too complex. I'm not going into it.
After having explained it.
Moving it on. But no, it's interesting. It's fascinating stuff. Yes. So now on the trademark side of things, one of the, I think, very useful forms of protection is, Mimi was talking a little bit about distinguishing guises, things in which you can acquire distinctiveness, but you may not necessarily have that distinctiveness from the outset. So these are things that are capable of being protected by way of trademarks, assuming that the consumers know that it's you, that these things came from, that they're distinctive of you. But you might not have that distinctiveness at the outset. And so what you could do instead is to file a design patent application or an industrial design application, two different names for the same thing. And you file that to protect, let's say, Apple's fancy click wheel. Before they ever started selling things that had the click wheel on it, they could have filed a design patent or an industrial design application and protected it by way of by that way. Now it only has a limited period of monopoly on it, but it would have been sufficient for them to acquire distinctiveness in that click wheel, such that when the design expires, they may be able to get trademark protection on it. And then when they have trademark protection, they may be able to renew that forever. So potentially, it's a way that you can add some serious value to your business. And I wouldn't be surprised if we see that as a trademark application in the coming years. Anyway, that's a serious interface. Another one is on the patent side. So while patents are to protect useful articles and the way that they work, designs protect these features of shape, pattern, ornamentation, or design that are applied to useful articles. So there's a clear connection there as well. And in fact, as I said a second ago, design in the United States, designs are protected by way of design patents. So you can see even in the name that there's some connection. So first of all, much like on the patent side, you should keep your designs confidential prior to filing. If you do publicly disclose them, then they are already out there in the public, and so you won't be able to protect them. And they must be registered in order to get protection. So unlike copyrights and trademarks, but similar to patents, you do have to apply for protection to get protection. And as I said, in Canada, you would do that by way of filing an industrial design application. In the United States, by way of filing a design patent application. As I said, there's a limited period of monopoly that you're afforded, unlike on the patent side where you get 20 years. On the designs in Canada, you get a maximum of 10, provided that you pay a maintenance fee about halfway through at the 5-year mark. And in the US, you get 14 years of protection. So it's a slightly different term as well. So what to look out for? Well, keep an eye on those features of shape, ornamentation, pattern, or design that are part of what you're doing. And one of the things that you might not have thought of, but it's a useful article that most people use every day, those icons on your desktop that, let's say, you use to launch an application. Well, the way that that appears, it's protectable by way of design. So, for every software program that you use, it probably has a different icon, and each one of those is capable of protection. As I said before, designs must be registered to protect. On the same slide, okay. And then they are subject to some of the same requirements as on the patent side. And so really the novelty and inventiveness requirements are basically the same. That the thing it must be new, and it also has to be not obvious. So something to think about. And last, I think really consider how designs can work with the other forms of protection that you might be considering, because it is a good way to boost out the protection that you might otherwise be limited by. And so in that respect, be careful to properly navigate some of the complexities of that explains why I intentionally didn't go through that other complex point, so you'd have to ask me about it either now or later. Anyway, we could talk about designs and questions associated with them, but I'd like to throw this table up here so that you can take a look. And it, I think, summarizes all the various forms of IP protection in, well, 3 columns, basically. So, so if there's any questions on any of these, we'd be happy to take them.